Imagine you are 40 feet in the air on a suspended scaffold, and the rigging suddenly gives way. In that split second, your life depends entirely on your fall protection gear. But if you spot a frayed lifeline before the drop, do you know the exact legal mechanism that protects you when you refuse to hook in? Before we break down those mechanics, we need to state clearly, this video is for educational purposes only and does not constitute formal legal advice. If you speak up about a frayed lifeline, your employer cannot legally fire, demote, or punish you. That protection comes from Section 11C of the Occupational Safety and Health Act. But here is the catch. You only have exactly 30 calendar days from the moment of retaliation to file your complaint with OSHA. Missing that 30-day window means losing your federal protection. Understanding these precise reporting rules is the absolute prerequisite for maintaining your job security while navigating dangerous site conditions. That legal shield is built on 4 core rights. The first is your right to know. Under updated hazard communication standards, you have absolute access to safety data sheets for any chemical you handle. You never have to guess what you are breathing in. Second is your right to raise concerns. As we saw with Section 11C, strict whistleblower protections guarantee you can report safety hazards directly to management or inspectors without facing termination or blacklisting. The third is the right to training. OSHA requires that all safety instruction must be delivered in a language and vocabulary you can actually comprehend. A highly technical manual handed to a non-native speaker does not count as legal compliance. The fourth is your right to records. You are legally entitled to review your employer's OSHA Form 300 logs, which track overall site injuries, as well as your own personal medical exposure records. By using these 4 tools to document site conditions and access hazard data, you gain the specific legal leverage needed to ensure your safety remains a priority throughout your shift. Sometimes, a danger exists that isn't covered by a specific rule. That is when OSHA deploys Section 5A1, the General Duty Clause. This mandate requires employers to keep workplaces free from recognized hazards causing serious physical harm, serving as the ultimate enforcement tool for undocumented risks. For 2026, enforcement is heavily prioritizing written federal standards for issues like heat stress and fall protection. But writing a standard in Washington is very different from implementing it on a sprawling construction site in July. To bridge that gap, the agency uses a strict inspection hierarchy. Imminent danger situations trigger an immediate response. Next come fatalities or catastrophes, followed by worker complaints, and finally, randomly scheduled programmed inspections for high-risk industries. When inspectors actually arrive on site for the walk-around phase, you have the right to speak with them privately. As you can see in this compliance check, officers hold direct conversations with workers, completely separate from management oversight. Without this rigid, hierarchical inspection mechanism bringing officers onto the floor, federal safety standards would be nothing more than ink on paper. This bar chart outlines the 2026 civil penalties, the financial teeth forcing employers to take physical inspection seriously. A serious violation, where an employer knew of a hazard causing serious harm, maxes out at $16,550 per violation. But if an employer intentionally acts with plain indifference, it's classified as willful. The penalty then violently leaps to $165,514. Companies can negotiate these numbers down. OSHA offers a 20% reduction for a clean history of compliance, and another 15% cut for good faith efforts to promptly correct the hazards. An unmitigated hazard represents hundreds of thousands of dollars in potential liability. Understanding this extreme financial leverage gives your safety reports real weight and immediate urgency when they land on the manager's desk. Navigating these regulations with precision changes your status on the worksite. When one willful violation can cost a company $165,000, the individual who can audit a site and prevent that fine moves from a laborer to a high-value risk manager. You can turn compliance into a tangible resume builder, listing credentials like your OSHA 10 or 30-hour cards or advanced trainer courses like the OSHA 500 and 510 instantly signals your operational value to a hiring manager. During interviews, use the STAR method, situation, task, action, result, to frame this knowledge as a leadership trait. Detail exactly how you audited procedures, like 29 CFR 1910.147 for lockout-tagout, and quantify the incidents you prevented. In the modern industrial landscape, proactive safety knowledge translates directly to the bottom line. It is a measurable metric of leadership that top-tier companies actively hire and promote for. Your physical safety relies on your core rights. Those rights are backed by federal standards, and mastering those standards directly accelerates your career impact. These regulations function as a legal shield and a professional differentiator. Know your rights, understand the standards, use this knowledge to stay safe and advance your career. To learn more about OSHA compliance, worker rights, and building a stronger safety career, subscribe to the HSE Study YouTube channel. Click one of the videos on screen now